further improvements to our intellectual property laws. I have every confidence that we can come together and act in a bipartisan manner. The stakes are simply too high for us not to seize this moment. Mr. President, I ask unanimous consent that further extension of my remarks be placed in the record at this point.
Without objection.
Mr. President, I yield the floor.
The senator from Iowa.
I rise to speak on S-23, the amendments. Probably have a lot of amendments, but right now we're talking about the bill. America Invents Act is what it's called. And I should express my gratitude to those of others that have helped so much on this, been quite frankly more involved on this bill than I have been. Chairman Leahy, Senator Hatch, Senator Sessions, Senator Kyle. But this is a bipartisan bill. Over the past 5 years or so, the Senate Judiciary Committee has been considering comprehensive patent reform. Chairman Leahy has engaged senators on both sides of the aisle, as well as a wide range of groups on the outside. His efforts have been pivotal in bringing together diverse views and crafting a reasonable compromise bill. In fact, the bill is supported by a large number of industries and other stakeholders from the United States patent community. I commend the leadership of Chairman Leahy, as well as the leadership of Senator Hatch, for getting us to where we are at this point. Intellectual property rights are extremely important to our nation's economy. An effective and efficient patent system will help promote innovation and technological advancement in America and make life better for us all. An effective and efficient patent system also will help provide stimulus for businesses and obviously generate many new jobs. Everyone agrees we need a well-functioning patent and trademark office within our government so that it can complete its work in a timely manner. We should find ways to help the Patent and Trademark Office speed up the patent application process and eliminate the current backlog that it is experiencing. We should reduce costs and decrease abusive litigation and improve certainty in the patent process and strengthen patent quality. The American Invents Act will help do all of these things. The bipartisan bill before us will update and upgrade the United States patent system. It will enhance transparency and patent quality, and it will ensure that the Patent and Trademark Office has the tools and funding to cut its backlog and process patent applications more quickly. The improvements to the patent system contained in our bill will help spur economic prosperity and job creation. I'm pleased, as you can tell, to support this legislation. Specifically, the bill would improve patent quality by establishing the opportunity for third parties to submit prior art and other information related to a pending application for consideration by a patent examiner. By allowing prior art to be submitted earlier in the process and explained to the office, patent examiners will be able to issue higher quality patents. The bill would create a first window post-grant opposition proceeding open for 9 months after the grant of the patent. This will allow the Patent and Trademark Office to weed out patents that shouldn't have been issued in the first place. This new post-grant review process, which was recommended way back in the 2004 report issued by the National Academy of Sciences, would enable early challenges to patents, but also protect the rights of inventors and patent owners against endless litigation. The reason we want to ensure that the Patent and Trademark Office issues high-quality patents is to incentivize investment in truly innovative technological advances and at the same time provide more certainty for investors in these inventions. In addition, our bill would improve the current inter-parties administrative process for challenging the validity of patents. It would establish an adversarial inter-parties review with higher threshold for initiating a proceeding and procedural safeguards to prevent a challenger from using the process to harass patent owners. It also would provide and include a strengthened estoppel standard to prevent petitioners from raising in a subsequent challenge the same issues that were raised or reasonably could have been raised in a prior challenge. The bill would significantly reduce the ability to use post-grant procedures for abusive serial challenges to patents. These new procedures would also provide faster, less costly alternatives to civil litigation to challenge patents. Our bill would institute a gatekeeping role for the courts to assess the legal basis for damages and jury instructions. This would provide more certainty for damage calculation and promote uniformity and fairness. The bill also would transition the United States to a first inventor-to-file system, simplifying the application process and coordinating it with our trading partners. This change will reduce costs and help improve the competitiveness of American inventors abroad. Further, our bill would provide fee-setting authority for the Patent and Trademark Office Director to ensure that the Patent and Trademark Office is properly funded and can reduce its current backlog of patent applications. Our bill also would mandate a reduction of fees by 50% for small entities and 75% for micro entities. I want to particularly thank Chairman Leahy for working with me and Senator Bogle on a provision that would curtail patents on tax strategies. These patents encumber the ability of taxpayers and their advisors to use the tax law freely, interfering with the voluntary tax compliance system that America has and is one of the high points of our tax system. Tax strategy patents undermine the fairness of the federal tax system by removing from the public domain ways to satisfy a taxpayer's legal obligations. If firms or individuals hold patents for these strategies, some taxpayers could face fees simply for complying with our tax code. Moreover, tax patents provide windfalls to lawyers and patent holders by granting the exclusive rights to use tax loopholes, which could provide some businesses with an unfair advantage in our competitive market system. So the provisions that Senator Bogle and I put forth would ensure that all taxpayers will have equal access to strategies to comply with the tax code. This provision was carefully drafted with the help of the Patent and Trademark Office not to cover software preparation or other software tools or systems used to tax or information returns or manage taxpayers' finances. So in concluding my opening statement on this legislation, the America Invents Act, will protect inventors' rights and encourage innovation and investment in our economy. The bill will improve transparency and third-party participation in the patent application review process. This, in turn, will strengthen patent quality and result in more fairness for both patent holders and patent challengers. The bill will institute beneficial changes to the patent process to curb litigation abuses and improve certainty for investors and innovators. It will help companies do business more efficiently in the international environment. The bill also will enhance operations of the Patent and Trademark Office with administrative reforms and will give the office fee-setting authority to reduce backlogs and better manage its business. So, I'm pleased to support this legislation. It's a hard-fought bipartisan legislation, and I urge my colleagues to support it as well. I yield the floor.
Thank you. Mr. President, I thank the distinguished senator from Iowa, and as I noted before he got on the floor, he's been extremely important in working on this issue. And if the senator from Louisiana could hold a moment, I have a unanimous consent request for committees to meet during today's session of the Senate. So on behalf of both the majority and minority leaders, and I ask that unanimous consent, this request be agreed to and the request be printed in the record.
Without objection.
And, Mr. President, just so I can have a moment to speak with the senator from Louisiana, I'm going to suggest the absence of a quorum.
The clerk will call the roll.
Mr. Kaka. Mr. Alexander.
The senator from Louisiana.
Thank you, Mr. President. Pursuant to my conversation with the distinguished committee chairman,
With all due respect, Senator, the senator's in the quorum.
unanimous consent to call off the quorum.
Without objection.
Thank you. And now, pursuant to my conversation with the distinguished committee chairman, I'd ask unanimous consent to temporarily set aside the pending amendment to call up the Toomey-Vitter amendment.
Without objection.
But I understand he will then set aside that amendment, at least temporarily, so we can go forward on some of the other amendments.
I have no problem allowing the other amendments to be made pending.
The clerk will call the amendment.
The senator from Louisiana, Mr. Vitter, for Mr. Toomey and himself, proposes amendment numbered 112. At the
I ask
appropriate
unanimous consent to waive reading of the whole.
Without objection.
Thank you, Mr. President. Mr. President, this Toomey-Vitter amendment is the Full Faith and Credit Act, a concept which has been discussed for several weeks prior to this week. But it is very timely as we're all rightly focused on the spending and debt issue with the Thursday deadline coming up. Mr. President, no one that I know of wants the government to be shut down in any way, shape, or form. No one that I know of wants any massive, significant disruption. But lots of people that I know of, including in Louisiana, want us to change business as usual here in Washington, starting with spending and debt. And this full faith and credit amendment is an important step in that regard. Mr. President, because of the time limitations in front of us before we move to other pending business at 4:30, I will agree to come back at a later time to fully lay out this Toomey-Vitter amendment as well as a second-degree Vitter amendment, which I will be advancing with regard to Social Security. But it is very important to have this pending, to put it on the floor, to start this debate with vigor about spending and debt, changing the fiscal policy of this country so we get on a more sustainable path. There's only one thing certain about this debate, Mr. President, and that is if we don't change the fiscal path we're on, it will lead to an economic disaster, an absolute economic disaster. So I urge us to debate these important proposals immediately, well before the Thursday deadline, and come to a strong, positive resolution. I'll be back on the floor soon with Senator Toomey to fully explain this, as well as the Vitter second-degree amendment. With that, Mr. President, I yield the floor.
Mr. President,
Senator from Utah.
I send a motion to the desk.
The senator from Vermont.
Mr. President, I understand the unanimous consent to go to, at 4:30, to go to judicial nominations.
The senator is correct.
Regular.
Then I'd ask regular order.
It's a regular order. Is it recognized?
Under the previous order, the Senate will proceed to executive session to consider the following nominations, which the clerk will report.
nomination, the judiciary. Amy Tottenberg of Georgia to be United States District Judge for the Northern District of Georgia. Stephen C. Jones of Georgia to be United States District Judge for the Northern District of Georgia.
Mr. President.
Under the previous order, there will now be 1 hour of debate equally divided and controlled in the usual form. Senator from Vermont.
Mr. President, the nominees we consider today are both from Georgia. They were both reported unanimously by the Judiciary Committee this year. Actually, they were also both reported unanimously by the Judiciary Committee last year. They were among the 19 judicial nominees who were ready to be confirmed by the Senate last year but were not. When there was objection to proceeding last year, the vacancies persisted. The President had to renominate them, and the Judiciary Committee had to reconsider their nominations. And I expect that the Senate will confirm them both tonight. I would hope they would do so unanimously. Both have the support of their home state senators. Senator Isaacson and Senator Chambliss have worked with President Obama and with me in connection with these nominations. While I'm encouraged that the Senate is proceeding today, I am disappointed that we did not consider these nominees and other nominees from California, North Carolina, and the District of Columbia before the President's Day recess. We used to be able to clear the calendar of nominations before recess. As I said, all 6 of these judicial nominees were approved unanimously, every Republican, every Democrat, on the Judiciary Committee weeks before the recess. When they are considered, I fully expect they're going to be confirmed unanimously by the Senate. Now, while we have the high judicial vacancies around the country, the Senate should be considering judicial nominations without unnecessary delays. Litigants all over the country are having a hard time getting to have their cases heard in courts because of all the vacancies. And when we have all these nominees that are on the calendar, having had unanimous support, both Republicans and Democrats in the Senate Judiciary Committee, we ought to at least bring them up, vote them up or vote them down, so that we can fill these vacancies. In fact, when these 2 nominations are confirmed, there's still going to be nearly 100 judicial vacancies around the country. That's too many. They persisted for too long. That is why Chief Justice Roberts, Attorney General Holder, White House counsel Bob Bauer, and many others, including the President of the United States, have spoken out and urged the Senate to act. Now, nearly 1 out of every 8 federal judgeships is vacant. 1 out of every 8. That puts at serious risk Americans all over the country. They have the ability to have a fair hearing. And the real price for being paid for these unnecessary delays is that the judges who remain are overburdened. The American people who depend on them are being denied hearings and being denied justice in a timely fashion, whether you're plaintiff or the defendant, whether you're prosecutor or defendant. So we can consider and confirm this President's nominations to the federal bench in a timely manner, especially when President Obama has worked with both Democratic and Republican home state senators to identify superbly qualified consensus nominations. None of the nominations on the executive calendar are controversial. They all have the support of their home state senators, Republicans and Democrats. All have a strong commitment to the rule of law. All have a demonstrated faithfulness to the Constitution. Now, during President Bush's first term, his first 4 tumultuous years in office, we proceeded to confirm 205 of his judicial nominations. Now, I mentioned that 100 of those were done in 17 months. During the time I was chairman, during his first 2 years in office, I was chairman for 17 months of those 24 months. We had had the case where 60 of President Clinton's nominations had been pocket filibustered by those on the other side of the aisle. I said, let's break this. And we showed good faith in moving 100 of President Bush's nominees in 17 months. The remaining 31 months, Republican control, they moved another 105. But so far, in President Obama's third year in office, the Senate's only been allowed to consider 67 of his Federal Circuit and District Court nominees, as compared to over 100 for President Bush. So we remain well short of the benchmark was set during the Bush administration, set by Democrats being in control of the Senate. And if we can approach what we did with President Bush, we can reduce vacancies from the historically high levels at which they remained throughout the first 3 years of the Obama administration to the historically low level we reached toward the end of the Bush administration. Now, I know the distinguished senator from Iowa is going to want to speak on this, and time has been reserved for him. So I will first yield to the senator from Pennsylvania on my time.
Mr. President.
The senator from Pennsylvania.
Mr. President, I rise to ask consent to speak as if in morning business.
Without objection.
Mr. President, I rise today to offer a tribute to honor Robert W. Bogle in the Philadelphia Tribune newspaper. Bob Bogle's family and many of his friends are with us here in Washington, D.C., who have traveled from Philadelphia and other parts of our state and beyond to be with us. And as we pay tribute to his leadership and his commitment to the Philadelphia African-American community and to all the people of the city of Philadelphia in southeastern Pennsylvania, I rise as well to honor the role that the Philadelphia Tribune, as a leader in the black press, has played in communities in Pennsylvania and throughout our state. This is the 5th year which I've come to the floor of the United States Senate to honor a prominent African-American Pennsylvanian as part of the celebration of Black History Month. Bob Bogle today joins the Reverend Leon Sullivan, Judge Leon Higginbotham, former Transportation Secretary Bill Coleman, and former Pennsylvania Secretary of the Commonwealth C. Dolores Tucker in being recognized this month in this way. But today we talk about Bob Bogle and the Philadelphia Tribune, and in a larger sense, the history and the future of the black press in Pennsylvania and across the country. But from the time that Bob was a young child, his life has been inseparable from the Philadelphia Tribune. Bob's father, John Bogle, was the advertising director at the Philadelphia Tribune, and Bob still reminisces about the playground that he lived in, which was much different than the playground that most children live in. As early as the age of 7, Bob would roam the Tribune building while waiting for his father to finish work. Bertha Godfrey, employed by the Tribune since 1946 and now a senior vice president, recalls a young Bob Bogle wandering around curiously, observing the production department and other areas of the production of the Philadelphia Tribune newspaper. In 1970, Bob Bogle started selling advertising for the Tribune and quickly worked his way up, impressing his colleagues and business associates alike. In 1973, he became advertising director, 1976, director of marketing, and by 1983, executive vice president and treasurer, before becoming president and chief executive officer of the Tribune in 1989. Despite his early exposure to the Tribune, Bob did not initially plan on a career in journalism. He attended Cheyney State College, now by the name of Cheyney University, to study sociology, and he earned a B.A. in urban studies. After that, and after it became clear that he was going to play a role in the management of the Tribune, he also attended the University of Pennsylvania's Wharton School to study marketing and economics. He's completed courses of study at Temple University and the Rochester Institute of Technology, and continues to this day to hone his newspaper expertise by participating in annual workshops in many areas of marketing and advertising and publishing. Now, Bob has become a role model for Philadelphia African Americans and for the community at large, and he served in leadership roles in a wide range of professional, civic, and social organizations. In the interest of time, I won't read those, but I'll make sure that they all get in the record. Bob's also been honored for his service and his leadership. In 2002, President George W. Bush appointed him to serve as a member of the National Museum of African American History and Culture, that commission in place at that time that he was named to. In the year 2000, he received an honorary doctorate of humane letters from Drexel University in Philadelphia. In addition, Bob has been a member of so many other organizations, too numerous to name. While he's recognized as a community leader in various realms, it is Bob's role at the Tribune and with the Black Press movement that stands out as his life's work. Today, few would question that the right to a free press as enshrined in the Bill of Rights applies to all. The right ensures that all Americans can participate in a vigorous and healthy debate necessary for a well-functioning democracy. But when our Constitution was first ratified, as we recall, most African Americans were not recognized as citizens and had few, if any, opportunities for participation in our democracy. It was not until a group of courageous men living in New York gathered some 30 years after the ratification of the Constitution that African Americans finally found an institution where they could, quote, plead their own case, unquote, as they said at the time. In 1827, editors John Brown Rossworm and Samuel Eliot Cornish published Freedom's Journal, the first black newspaper in America. The newspaper provided African Americans with a public square of their own, where they could participate in their own discussions and advocate for African Americans. As these two distinguished leaders wrote in their first editorial, quote, too long have others spoken for us, too long has the public been deceived by misrepresentations, unquote. While the Freedom's Journal was short-lived, it began what was no less than a revolution. Other black newspapers arose and began to explore subjects that were previously off-limits in the press of the day. New black newspapers delved into previously unmentionable hardships in crafting a new identity for freed and enslaved African Americans. Topics such as slavery and menial labor were examined by African Americans for African Americans. For the first time in the history of our country, African Americans were able to speak freely through a press of their own. In addition, African Americans could start announcing to the world some of their most precious moments in life, like births and anniversaries and deaths and other family news. The black press helped establish a new extended community of African Americans all across the United States of America. The black press expanded in the years prior to the Civil War, as over 40 publications across the nation provided African Americans with viewpoints on issues such as emigration to Africa, emancipation in the South of the United States, and of course, abolition and freedom. Frederick Douglass was one of the many who published a black newspaper in which he, like many others, urged African American men in the North to enlist in the Union Army. The post-Civil War era saw a period of rapid growth for the black press. The first daily newspaper, the New Orleans Tribune, was published in 1864, and newspapers continued to open across the country as African Americans migrated from the South. By the 1880s, it became obvious that the growing African American population in Philadelphia, Pennsylvania, needed a newspaper. Christopher J. Perry filled the void. Following graduation from high school, Mr. Perry moved to Philadelphia to start a newspaper because, he said, and I quote, for my people to make progress, they must have a newspaper in which they can speak and speak out against injustice, unquote. Mr. Perry's newspaper, the Philadelphia Tribune, often told a different story from a perspective other than that of the city's traditional newspapers. Mr. Perry and the Philadelphia Tribune quickly established themselves as leaders of the growing African American community in Philadelphia. The Tribune published stories highlighting black institutions across Philadelphia that were not reported by the mainstream papers. Mr. Perry championed the causes of the African American community, from covering important events to offering articles about champions of social and racial equality. Additionally, he provided a forum for African Americans to report on job openings, musical performances, and other happenings within the African American society. After Mr. Perry passed away in May of 1921, his children continued the traditions he began in the pages of the Philadelphia Tribune. The second generation of Perrys continued to fight for the equality of African Americans. Eugene Washington Rhodes, Mr. Perry's son-in-law, succeeded him as editor. As Dorothy Anderson wrote in a tribute, in 1958, quote, "In no year since the Philadelphia Tribune first burst upon the Philadelphia scene was there a single edition which did not press for equal rights, equal opportunities, and equal privileges," unquote, for the African American community. Eugene Rhodes continued to spotlight social issues around the city of Philadelphia and around the country by focusing on the northern migration during the 1920s and dangerous housing conditions for African Americans in Philadelphia during the 1930s. In addition, he provided a much needed, I should say, support for some of the first African American politicians in the city of Philadelphia, such as John Asbury and Andrew Stevens, the first African Americans elected to the Pennsylvania House of Representatives. Perhaps most importantly, the Tribune led the fight against segregation in the Philadelphia School District by creating its own legal defense fund and publishing many editorials championing the equality of African Americans. In 1940, the publisher of the Chicago Defender called a meeting of the major publications which made up the black press. He proposed that newspapers form an advocacy group to ensure the long-term survival of the black press. The Philadelphia Tribune was one of the newspapers invited to take part, and out of this first conference grew the National Newspaper Publishers Association. Over 200 newspapers are members today, and the association provides vital services to the black press so that its members can continue to report on the African American society and community. As the current president and CEO of the Philadelphia Tribune, Bob Bogle has continued the traditions of Christopher Perry while leading the African American community of Philadelphia into and beyond the 21st century. The Philadelphia Tribune is now the longest operating African American newspaper in the nation. Recognizing Bob's leadership, the National Newspaper Publishers Association has honored the Tribune 5 times with the Russ Worm Award, the association's highest honor for, quote, best newspaper in America, unquote. The award is named for John B. Russwurm, co-founder of, as I mentioned before, Freedom's Journal in the 1800s. Recognized, as a leading member of the black press, Bob Bogle has served 2 terms as president of the National Newspaper Publishers Association and is credited with increasing awareness of African American issues, values, and lifestyles. He is also a founding member and president of the African American News and Information Consortium, a group of premier black newspapers in some of the largest markets in the United States of America. Finally, Bob continues in his role as ambassador for the city of Philadelphia. He sees race as a leading issue still plaguing our nation, but he remains relentlessly optimistic. I'm quoting Bob here. "I'm deeply engaged in the community. I believe that Philadelphia, as the birthplace of America, is the best city in America. It's diverse, it has great size, and our success will come from our collective understanding of who we are." The Philadelphia Tribune, though it is dedicated to covering the black community, also honors diversity, and we have non-African Americans in every area of our business, unquote. I'm quoting Bob there. And of course, Bob has been not just a leader in the African American community, but a leader in the Philadelphia community at large. For many years, and especially active in the advancement of young African Americans who live in Philadelphia and the region. He describes his essential philosophy this way, and I quote, "To be responsible for what you do and be the best at it. We need to account for what we do. Accountability means responsibility and taking pride in your work and doing the best you can." Unquote. So says Bob Bogle, and these are good words to live by. They're words we can take to heart and strive every day in our own lives to live by. I am so honored to be able to offer this tribute today to Bob Bogle, to his team at the Philadelphia Tribune, and to in a larger sense, the history and, most importantly, the future of the African-American press, so-called the black press in the United States of America. So please join me today in honoring a man of strength, a man of character, accomplishment, and service, Robert W. Bogle of Philadelphia, Pennsylvania. Mr. President, I would yield the floor and note the absence of a quorum.
The clerk will call the roll.
Mr. Akaka.
Mr. President.
The senator from Georgia.
President, I ask that the floor comment
Without objection.
President, I rise today along with my colleague from Georgia, Senator Isaacson, to commend to this body the confirmation of 2 judges that have been nominated by President Obama for the Northern District of Georgia. First of all, Amy Totenberg is an Atlanta lawyer who certainly has the academic credentials that have prepared her well, being a graduate of Radcliffe College at Harvard and also the Harvard Law School. She began law practice in Atlanta in 1977 with the Law Project and then went out on her own for 20 years. During that time, as a solo practitioner, she specialized in constitutional rights and also became a well-known arbitrator and mediator, and particularly in employment and civil rights cases. She served as a court-appointed monitor and mediator for the U.S. District Court for the District of Columbia, and has served as a special master for the U.S. District Court in Maryland on an institutional education reform case. Ms. Totenberg has a wealth of experience in that issue, having served as general counsel to the City of Atlanta's Board of Education from 1994 to 1998, and also served as a part-time municipal court judge in Atlanta for several years. She also has been an adjunct professor at Emory University Law School. She's been deeply involved in her community in addition to her legal activities. Ms. Totenberg has been a member of the State Personnel Board, served as a member of the Governor's Education Reform Commission, and given her time to Hands on Atlanta, the city's largest volunteer service program. I commend Ms. Totenberg for confirmation today as her name comes before this body. Steve Jones has been a friend for a long time. He's one of those guys that pick a jurist. He's the guy, a defendant, or whether you're a plaintiff or a defendant in a civil lawsuit. Steve Jones is a native of Athens, Georgia, graduate of the University of Georgia, both as an undergraduate and as a graduate of the law school there at the University of Georgia. He began his legal career as an assistant district attorney, then became a municipal court judge, and then in 1995 he was appointed to the Superior Court bench for the Western Judicial Circuit, which covers both Clark and Oconee counties, 2 of our fastest growing counties in the state. And in his capacity as a Superior Court judge, Steve presided over both civil and criminal cases. He's also supervised the circuit's felony drug court for 6 years. Steve Jones' list of honors and awards are truly too numerous to mention here to this body, but he has been a member of the State Bar of Georgia's distinguished, he's been awarded the State Bar of Georgia's Distinguished Judicial Service Award, the Georgia Legal Services Program Georgia Justice Builder Award, the University of Georgia President's Fulfilling the Dream Award, the Boy Scouts of America's the Distinguished Citizen Award, and the Chief Justice Robert Benham Award for Community Service Beyond Official Work, and the Julian Bond Humanitarian Award. He's been very active in the Athens and Clark County community. Steve is just a wonderful person, a great family man, a great community citizen, and just an outstanding jurist. He's going to make a truly outstanding district court judge on the Northern District Court in Atlanta. With that, I would yield to my colleague, Senator Isaacson.
I thank you, Senator Chambliss. Mr. President.
The senator from Georgia.
Mr. President, I rise to second the statements made by Senator Chambliss on these 2 nominees to the Northern District of Georgia Court, Amy Totenberg and Steve Jones. Amy Totenberg is an attorney of practice for many years, a judge, an arbitrator, a mediator, and an educator. She brings a wealth of experience to the bench in many, many areas, not the least of which is personnel law. In fact, during her term of service to the Atlanta Board of Education in the mid-1990s, I was chairman of the State Board of Education and dealt with the major litigation pieces that went through the system of education in Georgia. I know of her competence, her ability, and the trust that her colleagues have in her, and I think she'll be an excellent appointee to the Northern District of Georgia bench. Steve Jones is the real deal. He is a terrific individual who is one of those people who is so active in trying to make the community better. Just one example is Clark County in Athens, where Steve has been a Superior Court judge for a number of years, is one of the leading and founding drug courts in America. An intervention court that intervenes in those first drug cases when young people get caught for the first time, work with them as an advocate and as a mentor to see to it they never return to drugs and therefore never return to crime. That's just one example of his intensity in trying to make his community better. He is respected by lawyers throughout the circuit. He's respected by his fellow judges, and he's deeply respected by me as an individual who brings great credit to our state and great credit to the bench. I urge all our colleagues tonight on the vote for Steve Jones and Amy Totenberg to unanimously support both these nominees to the Northern District of Georgia bench. And I yield back.
Mr. President,
Senator from Iowa.
we're continuing in a cooperative effort to fill vacancies in the federal judiciary that have been designated as judicial emergencies. Today, the Senate will confirm 2 more of President Obama's judicial nominees. I am pleased that we're moving forward on a consensus basis and also consensus nominees who will lessen the burden on our overworked courts. My Republican colleagues and I continue to demonstrate our ability and desire to work with the President and the Democratic majority. We will have confirmed 7 judicial nominees in just 17 short days, and the Senate has been in session this Congress. We have reported out of committee a total of 15 judicial nominees, or 29% of the total nominees that have been submitted. We have already held 2 hearings in committee on 8 judicial nominees, with additional nominees scheduled for a hearing later this week. With this quick and productive pace, we have taken positive action on 55% of the judicial nominations sent to the committee this year. I continue to work with the chairman to ensure all nominees are afforded a fair but thorough process in a timely manner. I have appreciated the chairman's courtesy as we work together to set schedules and agendas. It is imperative that the administration work with us as well as to fill vacancies. I am particularly concerned about those seats designated as judicial emergencies. We continue to hear about the high judicial vacancy rate. I think the record is clear that the Senate is addressing the issue in a vigorous manner. However, I continue to note that the President has failed to submit a nomination for over half of the vacancies. For judicial emergencies, over 57% of those seats have no nominees sent to the Senate yet. The 2 vacancies that we're filling today took some time for the nomination to be sent to the Senate. Both seats became vacant December 2008, and that was at the end of the Bush administration. It took President Obama over a year to nominate for 1 seat and nearly a year and a half to nominate for the other seat. So those who are concerned about the high vacancy rate in the federal judiciary should pay attention to the nomination process and not just to the Senate part of that process that we call Senate confirmations. I will say a few words about the nominees who are scheduled to have votes today. I thank our leadership for the reasonable arrangements that was reached to consider these nominations. First, Amy Totenberg is nominated to be a U.S. District Court judge for the Northern District of Georgia. She received her A.B. magna cum laude and her J.D. from Harvard University. Upon graduation, she joined the Law Project as a partner, where she focused on federal constitutional and employment law. She left the Law Project to become a solo practitioner, where she maintained a general civil practice. Ms. Totenberg also served as municipal court judge for Atlanta and was appointed by the Atlanta Board of Education as the first in-house general counsel for the Atlanta Public School District. Over the past decade, while maintaining a solo practice, Ms. Totenberg has spent the majority of her time as a special master, monitor, and arbitrator/monitor for the U.S. District Courts of Maryland and Washington, D.C. The American Bar Association Standing Committee on the Federal Judiciary unanimously rated her well qualified. The second nominee, Steve C. Jones, is also nominated to be a U.S. District Judge for the Northern District of Georgia. Judge Jones received a BBA and his JD degrees from the University of Georgia. An experienced jurist, he began his legal work as an assistant district attorney for the Western Judicial District of Georgia. In 1993, Judge Jones began service as a municipal court judge for the Athens-Clarke County, Georgia. He was appointed by Governor Zell Miller in 1995 to serve as Superior Court judge for the Western Judicial Circuit. He was subsequently reelected 4 times and is the presiding judge of the Felony Drug Court. Aside from his daily duties on the bench, Judge Jones was appointed by the Georgia Supreme Court to serve on the Judicial Qualifications Commission. He also functioned as chairman from the years of 2002 to 2006. On and off the bench, Judge Jones has contributed to his community. He has invested time to help Georgia Legal Services as well as local anti-poverty initiatives. Partners for a Prosperous Athens/One Athens anti-poverty group. The American Bar Association Standing Committee on the Federal Judiciary unanimously rated him well qualified as well. I support these 2 nominees and congratulate them on their achievements and their public service. I will continue to work with the chairman to move forward on consensus nominees as we have done with these 2 nominees. Thank you, Mr. President, and I would suggest the absence of a quorum.
Clerk will call the roll.
Mr. Akaka.